attending today. We appreciate it. We're going to present a 2-hour CE credit, which is 100 minutes. We'll go straight through. And I think you'll like this one. It's basically what happens when asset protection plans fail or they're approached in the wrong way and assets are exposed. I'm going to get right into it. I'll get to the slides. So we're going to take me out so you can see everything, if I can do it. There we go. There it goes again. Let's try it again. All right. On the agenda today is basically we'll go for the first 50 minutes. We'll talk about, generally how asset protection works. What are the general structural methods that we use for asset protection? Basically, if you follow these structural methods over time, you don't have an issue going on when you start your asset protection plan under blue skies. Things work very well. I've been doing this. I spent the first 9 years doing M&A work, and then I got into asset protection and estate work, and we've never had a plan breached. So if someone comes in, I know we have a lot of CPAs on the line. If someone comes into you and they have no litigation, they have no, it's a doctor and he didn't leave the scissors in the patient or whatever. These structures are very trodden, very reliable. It's very unlikely that anyone's going to reach these assets if an asset protection plan is put in place before any problems arise. What we're going to talk about today is what if problems are going on? What if the structures has weaknesses? But initially we'll talk about the background, and then we'll get into the reasoning why some of these plans are breached. And it really almost always comes down to you're dealing with a bad actor or a criminal who's trying to use asset protection vehicles for bad purposes. And then we'll get into fraudulent transfer, which is the principal law at every state and almost every English-based common law offshore jurisdiction has fraudulent transfer laws, and that's basically the way to go after an asset that was moved away from somebody. Somebody gets into trouble, they say, well, I'm going to give my car to my cousin. You can go get the car if you're the creditor. That's fraudulent transfer laws. It's extremely detailed. I'm going to try to give you the practical side of fraudulent transfers. It's really its own area law, but that's the vehicle. That's the vehicle, and when you go into an asset protection plan, that's the vehicle you want to make sure you comply with so that your plan holds up. We get into bankruptcy a little bit from the sense that we kind of want to avoid bankruptcy. Bankruptcy is a great way to discharge assets if you've become encumbered in debt, but it's not a great way to retain assets. The laws change, the rules change. It's kind of something that would typically be avoided by a client who has assets. And then we'll get into some of these issues, weakening asset protection plans involving the single member LLC and the choice of law. And then some general tips, and we'll wrap it up. We'll try to wrap it up. Let's see, so that's 100 minutes. So that would be 10:40. So around 10:30, we'll take questions. And if you have a question, just click on the question. There should be a little question bar in the screen, or a little raise your hand section, and Tony will send the question to me. We like questions. It breaks it up a little bit. We want you to participate. Also, there's a huge amount of material. If you have a question, if I'm going too quickly, or there's some complexity you want some more detail on, just send me a question, and we can stop at any time. It's not a problem. Actually, it kind of makes for a more interesting presentation a lot of times if you ask questions. So, what is asset protection? Asset protection is basically preparation for later litigation, whether it occurs or not. What we want to do is we want to take holdings, both corporate and individual holdings, and without losing benefit and often control in many ways of the assets, of the value. We want to use what's available structuring wise to protect what we have. And we want to do that before there's any problems, so that if we run into a problem later, we're ready to go. We don't lose what we have. It's very powerful. The reason, I've been so involved in it over the last 20 years is because there's really not a big drawback to it. A lot of clients think that you lose a lot of access, or you lose a lot of value, or you okay, can I sell my business after I asset protect it? Yeah. I mean, also there's a lot of flexibility. You don't have to take the most protective or structured route, but everyone, in my opinion, who has significant assets should at least look at their current situation to determine if in fact they can improve it from a protective standpoint. It's not, we have some things here on the side, it's not hiding assets, it's not evading taxes. Every couple months someone will call like, I want to hide this, or I want it. That's not what we're doing. We're basically utilizing existing law to provide you a more protective structure. The basics on asset protection come in these 4 or 5 areas. Titling, for instance. I know we're talking to a lot of New York CPAs today. In Florida, for instance, we have tenancy by the entirety. If husband and wife title either personal property or real estate together, jointly together as tenants by the entireties, if a plaintiff sues one spouse, that asset's not available to the plaintiff. Both spouses have to be liable to expose the asset. So you can actually use titling to layer asset protection. If we're worried about an LLC, if we have to use a jurisdiction that's not protected, for instance, we title it by the entireties if they're Florida residents. If they're New York residents, in general, you can't do that. What we do in New York is we take the argument that, for instance, Delaware allows for tenancy by the entirety. So we create a Delaware LLC and we title it by the entireties. The law is unclear whether if you're now resident in New York, can you take advantage of tenancy by the entireties because you've used a Delaware LLC? I say yes, but the jury's out on that. But at least you can make an effort to properly title an asset. Other titling like joint tenants, tenants in common, not protective. A lot of people, they'll hand us our a security statement from Goldman or whatever, and it's joint tenants. Well, joint tenants does not protect that account. If someone sues wife, they get half the account. And the same for the husband. It's not like tenancy by the entirety. That's just something, that's a little pearl that a lot of people don't understand, and that's really something that should be a focus of a lot of the planning. Exemptions, certain assets are just exempt. In New York, you've got an exemption on life insurance. In Florida, we have an exemption on, for instance, life insurance and the homestead, and a number of different annuity exemptions. These assets, it's not a titling issue. It's not an LLC or trust. It's there. You just can't get them. 401k, this kind of thing. You have to be very careful to satisfy the exemption. For instance, in Florida, if the owner of a life insurance policy is sued, you can still lose the life insurance policy. Only the insured, creditors of the insured, are blocked. So if the insured doesn't own the policy, for instance, you've got 2 partners who hold a policy on each other across purchase arrangement in a business entity, and it's let's say it's whole life or some kind of valuable life insurance. Well, partner 1 is holding it on partner 2. Partner 1 is not the insured. so they'll lose the policy if they're sued. In New York, the protection is different. I've got a chart in my book. If anyone wants a copy of my asset protection book, at the end of the program, we'll give you all the information. I'll send you the book. Just send me an email. I'll send you the book. There's also a international tax book we recently published that you might benefit from as well. If you want the book, like I said, at the end, we'll give you the contact information. And then you have entities. Sometimes I call trust entities. Sometimes a lot of people say trust's not an entity, but trusts are an interesting arrangement, let's say. Trusts started in the 16th century. Basically what happens is my son is home, he's young, I'm going off to war, I need to protect the assets to make sure that my son's taken care of. So I'm going to appoint a trustee to control the assets and manage the assets and make distributions from the trust, but the trustee does not benefit from the trust. My son benefits. My son's the beneficiary of that trust. So what happened in the 16th century is that title was divided by trusts. So if someone sues the trustee says, well, I'm not the beneficiary of the trust, so there's nothing really to get from me. If someone sues the beneficiary and it's a discretionary trust, that means that the trustee can decide when to make distributions. The beneficiary says, well, I can't get to the assets. It's the trustee decides when to make distributions. And thus was coined the trust fund baby. So you have beneficiaries of trust who are paid by the trustee when the trustee wants to pay them, which is every month, generally. Yet, if the trust fund baby gets into a car accident, there's nothing to reach. Still true in most jurisdictions. Some jurisdictions have created some exceptions to that for onerous situations and divorces and stuff like that. Typically, you want to stay away from those jurisdictions because you never know what's going to happen if you're a beneficiary suit. And then you have entities, LLCs, corporations, etc. We'll go into that toward the end of this presentation. We say entities because they're filed, articles are filed with the state, and generally they're business entities. Of course, you have family business entities and you have family investment entities, etc. But those have to do with both limiting liability with respect to what happens inside the entity, the old corporate protection. That's the corporate veil. In other words, what goes on in the corporation stays in the corporation. I'm not liable as a shareholder for what happens. And then you have the outside protection, which is if an owner of an LLC is sued, they can't reach the owner's equity in the LLC. That's outside protection. That's an LLC issue, partnership issue as well. We don't have much partnerships anymore. Not a corporate issue, by the way. If you've got a corporation today, I don't care what state you're in, really, you're probably in the wrong entity. If someone sues the owner of corporate stock, that corporate stock is completely exposed. I know that a lot of times we'll say, okay, the client will say, we have a shareholders agreement. That doesn't change the fact that if one partner, one shareholder is sued, that the stock's exposed. It just allows the other partner a right to purchase that stock. And in some states, I'm not sure that's even true. In some states, you can't just trigger a purchase just because someone gets sued. I'm not sure that creditor wouldn't win that case and take the stock. No reason to be a corporation really anymore for small, medium-sized business. There are some advantages if you're going public, but I mean, obviously that's a very, very small amount of corporations. Almost all of those corporations should convert to LLC status to get that outside protection of equity. If someone's sued, you don't want that equity exposed. If you have any questions on that, just ask Tony or just call me anytime, no problem. At the end of the slide here, we have similarities and distinctions of trusts and entities. The The trusts are a complete division of title. So they're pretty much bulletproof unless there's hanky-panky going on. That's a really strong entity. The business entities are not, you don't divide title. An owner's an owner. If you have someone who operates the entity, they operate the entity, but they're not the owner, and there's not really divided title. There may be divided operational authority and ownership, but not divided title. Let's go to the next slide. Yeah. So this presentation is going to focus on basically the fact that when we create a plan, we create a plan on in a day where there's not stormy weather, blue skies. Where we run into problems is where we have bad actors utilizing these protective strategies for bad purposes, and often to transfer assets running away from someone else, which is in and of itself going to be just stupid. Here's the first and old school way to reach through protective planning is what's called the alter ego. And that's why, CPAs, this is why you say, we're not going to run all your personal expenses through the entity. We're going to separate that. We're only going to use business expenses. We're only going to operate on business terms through the business entity. Otherwise, it looks like the entity is you. So every state has a line of cases that talks about alter ego and the fact that it's just really the individual. We're not going to create a corporate veil. We're going to go take the assets because it's just them. There's no corporate structuring at all there. It's just pretend. That's alter ego. Now we get into fraudulent transfer. Fraudulent transfer basically has to do with, I had mentioned this briefly before, the idea of, I think I'm going to get into trouble, or I'm in trouble and I'm going to lose money, and I'm going to just move things out of my name. I like this little comedy thing on here, this little comic. What condo? Yeah, oh no, I'm going to take it. I mean, we'll get a few calls every year. We're just going to move it out. It doesn't work like that. It doesn't work like that. This is a very old law. Every state's adopted it, where if you're a creditor and you get a judgment and someone has moved things out of their name, you can go get them. And that's the fraudulent transfer law. It allows you to unwind a protective transfer if it was made with the intent to avoid a creditor. The general rule, very, very few, even lawyers understand this general rule, is, until someone has a judgment against you, you can transfer whatever you want. You are not bound by anything that stops you from moving your assets around. What the fraudulent transfer rule does is it allows the creditor to go and get the asset from whoever you sent it to. But in terms of you being a defendant, that's not a problem. You can do whatever you want. It's just subject to the fraudulent transfer, and that's this Grupo Mexicano. That's a Supreme Court ruling. They made that absolutely clear, and that there's no, repercussion really. There's no penalty to fraudulent transfer, except that someone can go and get the asset. Now, of course, when someone does a fraudulent transfer and you're moving an asset to avoid a creditor, you've got to be super careful because you're involving the transferee. You're now the transferee, your cousin who got the car, is going to get sued. And that can be kind of unpleasant, to be perfectly honest with you. So you have to take that into mind. There's no repercussion. There's no financial or other repercussion really. We'll go into bankruptcy a little later, but you're going to involve other people, and it's not pretty. So when we talk about fraudulent transfers, we basically show this intent to avoid a creditor. And you can do it through, and you can prove that as the creditor two ways. One way is actual, and one way is constructive. I don't want to get too lost in the weeds on this, but it's kind of a basis for the whole reasoning behind, upsetting the apple cart on an asset protection plan. That's it's kind of the basis for the whole seminar. I went one slide to it. Yeah. The first one is actual intent. So if someone actually intends to avoid the creditor, and how do you show it? It's what someone's thinking. How do you show that? And I'll tell you, we've been involved in dozens of these cases. It's pretty hard to prove. It's pretty hard to prove. And we'll go through some of the reasons why, but it's pretty hard to show exactly what someone's thinking. So what the law has developed into basically proving actual intent through what are known as badges of fraud. Badges of fraud are like, okay, these are little factors, not one of which is really determinative, but these are little factors that you can show that suggests someone was engaging in a fraudulent transfer. And if a guy's, he was running out of his house, he had a bag of cash, he was in a big hurry, he didn't lock his front door, you know what I mean? And he was on the way to an island, that's what they mean by badges of fraud. Flight, you have the debtor absconding, concealing assets. Well, obviously, they're trying to avoid someone. They're trying to escape from paying a debt. That's actual. If you can prove that, you can prove they did a fraudulent transfer. Otherwise, and really in many ways more common, is constructive. Constructive means you don't have to show what they were thinking. Basically, if you can show that someone transferred an asset away, didn't get back value, right, and became insolvent for asset protection purposes, that they did a fraudulent transfer, and you can go get the asset. So unpacking that, what basically, if someone moved an asset out but didn't get an asset back, that was exposed. So someone has a piece of property, it's in their own name, it's totally exposed, or a corporation we had mentioned, and they move it out of their name into a protected title, right? Don't get back something that's unprotected that the creditor can get, right? And it made them insolvent for asset protection purposes. So they moved out a valuable asset, didn't get a valuable asset back that was exposed, and there's nothing else to get. They're insolvent. Then you can show that they constructively did a fraudulent transfer. Interestingly enough, if you can show that, you don't have to show intent. I mean, they actually might not have even intended it, but if you can show this constructive intent, you can prove fraudulent transfer. It gets into, because it involves this insolvency issue, in other words, the person no longer had any assets that are available, all kinds of factors come into play. We wrote a Florida bar, I believe a Florida bar article. I want to say Florida bar AB. I think it was a Florida bar article, now that I'm thinking about it, on what happens with this insolvency. In other words, how do you prove that someone became insolvent for asset protection purposes? And then if you're the debtor, how do you prove that you didn't, right? So it's assets, you guys are the accountants, it's assets versus liabilities, right? But what if a liability is unclear? What if the liability, what if you're in litigation and it looks like you're going to owe 100 million, but you might you might end up owing 20 million. Well, their cases kind of come down with some kind of probability issue. So if the most likely outcome is you're not going to owe anything, or you're going to owe a lot less than the demand, well, your balance sheet just got better. Maybe you're not insolvent, and if you're not insolvent, it wasn't a fraudulent transfer. So you go through these factors, and it becomes a very technical discovery process. You need appraisers, etc., to figure out if there was a fraudulent transfer, which really just comes down to, was I trying to hide the assets from somebody else? And it's true on the insolvency, and also like the other factors, when you move it out, did you take something back? Often that's a lot easier to prove, because typically when somebody moves it out, they're not going to take back something that's exposed. They're going to put it into a trust, or they're going to give it to their cousin, or whatever they're going to get. And if they didn't get anything back, that's enough to prove that fact. Other collateral, etc. So here's the breakdown of what happens on constructive intent. And a creditor can be a present creditor or a future creditor. I know that sounds very odd to most people. So a present creditor is a creditor, like a lender, who was owed money at the time of the transfer, right? So I owed you money. I was running out of assets. I know you were going to try to collect, and I got out of town. Or I transferred them, to Cook Islands or whatever. That's a fraudulent transfer. The other are future creditors. That's a creditor who became a creditor after the transfer. And that's kind of all it says. By the way, we'll talk about what is a future creditor. It's a creditor who became a creditor after the transfer. And so a present or a future creditor can prove constructive fraudulent transfer if the debtor can no longer pay his or her bills, right? That's insolvency. They can no longer pay his or her bills. So if you're a future creditor, you actually have to prove that the debtor can no longer pay their bills to prove constructive fraudulent transfer. Again, I know this gets a little entwined, so please ask any questions if you have it, no problem. And then if you're a present creditor, you were a creditor at the time of the transfer, it's just a balance sheet test. It's assets versus liabilities. That's it. You don't have to prove that they can't pay their bills. These other factors here very rarely come up, this antecedent debt and some of this engaged in a business with unreasonably small amount of assets. That's not really the issue. The issue that comes up all the time is this solvency issue. And if someone comes in and we're not planning, it's someone who's got a problem, we'll do an analysis for them just to kind of give them a roadmap with respect to where they stand in terms of their exposure to fraudulent transfer. A lot of times what happens is you can kind of save these transactions by just not becoming insolvent. If you didn't intend to do a fraudulent transfer and you kept some exposed assets in your name, you're not insolvent. So that whole line of cases, that ability of a creditor to reach your assets, kind of goes away. So this is just some limits on the rights to transfer assets, and that's what the fraudulent transfer laws do. If it can be proven that a fraudulent transfer took place, you can enjoin whoever got the assets from moving them again. You can attach and collect them. But as I had mentioned, pre-judgment, there's not that much you can do. The debtor can move whatever assets they want around. There's some rare exceptions to that, but that's pretty much the rule. Each state is going to have its own Fraudulent Transfer Act. Florida has the Uniform Fraudulent Transfer Act. New York adopted the new Uniform Voidable. I think it's Uniform Voidable Transfers Act. I should know that, actually. We wrote an RABA article on it several years ago when it was passed. But it's a new act, and it does add some interesting provisions, some clarity. The differences between the various acts, I've got a list of them on a later slide here, is somewhat significant in some ways, but in terms of understanding from a CPA perspective, especially how fraudulent transfers work, it's not that significant. It's when you're moving assets away from someone and they can prove that you did it to avoid them, or they can prove that you basically went insolvent. We had mentioned existing creditors, future and contingent creditors, possible creditors. What about possible creditors? What if we made transfers and later somebody became a creditor and they can prove that the transfers were made, we didn't receive back adequate consideration, and we became insolvent for asset protection purposes. We no longer had any exposed assets. Well, the actual law doesn't really care. It says, if you became a future creditor and those assets were transferred in that way, you have a claim. The courts have a lot of trouble with that. The courts typically have a lot of trouble with that, because if you were not contemplated at the time of the planning, the courts have pretty much always will uphold the planning. Let's go through a couple cases. So this is a negative. This is where the debtor lost. Kilker v. Stillman. So we had Stillman, who he just kind of messed it up from a approach, attitude standpoint. California, we find will also go out pretty far in their rulings. This is I think an example of that. Stillman had built a number of swimming pools in a development in California. That's what he did. A number of years passed. During those years, he had contributed his assets to a asset protection trust in Nevada. It's a very good jurisdiction for that. If someone's single, for instance, it's one of the only ways to really find a good means of asset protection, the domestic asset protection trust. He did it right. He had counsel. He pretty much protected everything he had. Many years then passed, and something went wrong with the development. He was brought into the suit. It was really after the statute of limitations had passed on fraudulent transfer. We'll get into the statute of limitations issue. That becomes a huge issue with these things. As much as the substance, determining insolvency, the statute, you've got to catch the statute. If the debtor is late on that statute, there's just no claim. The statute, from what I could tell in the case, it's a very short case, had passed. But because Stillman went in and was very cocky with the court, he said, "There's just nothing to get. You guys are out of line. I'm not gonna cooperate." He actually entered into a settlement agreement and then reneged on it, which the courts just hate. And the courts basically said that, no, we're going to ignore the statute and we're going to ignore the trust, and you owe the money. They just completely went on a limb because he had pretty much ignored the court and violated his settlement agreement, and said, look, if you're engaged in asset protection planning, you made a fraudulent transfer. Just keep in mind that if you have the wrong approach, the courts are very unkind to this. Also, in general, you have to be very conservative with asset protection. There's going to be a litigation. There's going to be a pleadings. The judge is involved. There may be a trial. the judge is involved. This might have gone on for 6 months, a year, depending on your state or your country. Could be years. And then you get to the end of the litigation. The plaintiff wins a judgment. The defendant says, "That's great. There's nothing to get." Well, the court's gonna find a way a lot of times to try to get that judgment paid, because the whole thing became a colossal waste of time. In Florida, a little more than New York, I mean, we kind of get that out up front, because people are just not, in general, willing to spend the time and money on litigation that's going to result in them being able to reach no assets. That's the power of asset protection. That's why we really focus on these kind of kooky cases in some ways, because there are no other cases, because people don't pursue them because the assets aren't available. It's very strong unless you go off the ranch like Stillman did. Hurlburt v. Shackleton is a Florida case which talks about the future creditor. Okay, so Dr. Shackleton, I think he was an internist actually. It's a fairly old case, and it's still law in Florida as far as I know. Did some very mild asset protection, I believe it was in the 80s. And he basically put his wife on their major assets. So he and his wife own tenancy by the entirety, which requires a plaintiff to have a judgment against both Shackleton and his wife to reach the asset. Years passed, and he was basically found negligent and owing a judgment to a patient. But when he did the asset protection work years before, he had no idea of knowing that this particular patient was going to sue him. So was this a future creditor? According to the black letter, I mean, this person became a creditor. Did he make himself insolvent when he did his asset protection? Yeah, he did. But the court said basically, you can't be a potential creditor. You can't be completely someone that is not contemplated when asset protection goes on. You have to have the intent, the actual intent, to avoid the individual. You can't go with a class like patients. It's got to be someone you think you may have harmed. And so she had no claim in Florida. The law I had mentioned started in the 16th century. In the U.S., you had the Uniform Conveyance Act. You have a Bankruptcy Act. The bankruptcy, by the way, and we'll get into some detail with that, is quite a bit more onerous. And when you talk about statute of limitations, it's a 10-year statute on certain asset protection transfers. So it's quite a different. It's like a ring of fire. You know, if you're going to bankruptcy, you just have to know you're in a totally different set of rules. And then you have a later act in the U.S., Uniform Fraudulent Transfer Act. That's Florida. And then you have Uniform Voidable Transfer Act, which New York adopted. I think it's 16 states have adopted. That's the brand new one. We can get into some of the key changes. One of the changes that has been just dogging the whole area of law was this idea of, it still does actually, of the name fraudulent transfer has the word fraud in it. But fraud, common law fraud, is, to mislead someone for financial gain. Fraudulent transfer has nothing to do with that. You're not misleading anyone. You are trying to move something like away from someone you owe money to. But fraud itself has a whole different set of rules associated with penalties and litigation. Also, it affects the attorney-client privilege. It's a different claim. The common law leading up to it, the cases, and every state is different. Fraudulent transfer is just a remedy to reach an asset that's been moved outside, away from the debtor. Anyway, the two get confused. The Uniform Act, the new act, which New York adopted, does go to some extent to clarify the difference that fraudulent transfer is not fraud. At the bottom of the slide, what happens here, though, and we'll go through a couple of cases, is that if you're in a jurisdiction or you're in bankruptcy and there's a fraudulent transfer, the standard has been confused. And you have to be very careful, because if you've done a fraudulent transfer or you're going to do one and you disclose it to your lawyer, that might not be protected communication. There's something called the crime fraud exception to the attorney-client privilege. It's technical, but it can be very exposing, because what happens is if they figure it out, if the other side figured it out and you're the debtor, they get to all your communications. It's an eye-opening thing. I've actually never gone through that claim, but it's happened a number of times throughout the country, and I think it's going to become more common as time passes. And I'll tell you why here with these cases.
Gary, before you get into the cases, we have a couple questions. I'm wondering if you'd like to take them now, or
Sure.
you want to
start taking questions.
Okay, great. So just to remind everyone, if you have a question, type it into the question section. So let me read the ones that I have here. Regarding domestic asset protection trusts, can the grantor act as the trustee? So domestic asset protection trusts, can the grantor act as the trustee?
That's a great question, actually. That doesn't come up much, that question. So the way that the domestic asset protections work is you only have 16 states that offer them. And the protections a lot of times are derived from the idea, and often the requirement, depending on the state, that the trustee is in the state, right? So if you're in New York or you're in Florida, you don't have a domestic asset protection trust statute. So you have to hire a trustee in Nevada, in South Dakota. So practically speaking, you can't be trustee, right? Now, if you live in the state that offers a trust, depending on what the statute is in that state, you could be trustee. You just have to be careful because, so technically you could be trustee. It would not be recommended because of what's called the merger doctrine. So if you act as trustee and you're the beneficiary or a beneficiary, the argument is, well, what have you done? Right? You're deciding when to make distributions, and you're getting the distribution. So there's a line of cases in a number of states that says if you do that, we can ignore the trust. So I think technically you could probably do it if you lived in the particular state. Would not be recommended. What's the next question?
Yes, and another one. This is kind of similar. What's the difference between a trustee of a trust and an LLC manager? So trustee of a trust and an LLC manager.
So a trustee of a trust is technically the legal owner of the assets in the trust. So legally, the trustee can contract regarding those assets, can move those assets around, can invest. If you've given the trustee the investment power, you can also divide that, by the way, which we do a lot. The trustee owns the asset. And I'm talking about a trust like an asset protection trust where the trustee has discretion on distributions. But the trustee cannot benefit from the asset. So if someone sues the trustee, you can't get into the trust, right? And then the beneficiary is the one who gets distributions. In an LLC is really a business entity at heart. The owners are the members. So the manager does not have to be an owner. A manager can be an outside manager, or the manager can be an owner. The actual protections don't change. If you have three people go in and they start a real estate LLC and they have a number of properties, and one of them's the manager, well, that's fine. The manager does the administration, and then the owners are the owners. It's the trustee having the position. I mean, the manager having a position as manager and being an owner is just like a corporate structure. They're not liable for what happens inside the entity. The owners are not liable for what happens inside the entity, but the owners can determine distributions. The owners can fire the manager or become the manager. So you can see why it's not quite as protective in general as a trust, right? Because the access to the assets is still in the owners and in the owner's hands. It's really it's a business entity, where the trust, the beneficiary does not technically have access to those assets. It's only the trustee. You can change trustee, but you really shouldn't become trustee, or you expose the trust. So it's kind of a business entity versus truly moving title to somebody else who can make a distribution. That's the difference.
Okay, great. That's all the questions I have for right now. Let's continue with the presentation.
Okay, great. So we're going to finish up in our first hour here fraudulent transfers. And these are some of the changes that the new Uniform Act made. Everyone's probably asking, what's the Uniform Act? Blah, blah, how does that work? There's this commission. It's a uniform commission, and they kind of tackle these different laws. And what they try to do is create uniformity throughout the states. Sometimes they do a great job. Sometimes they don't do a great job, because especially with asset protection laws, there's kind of a political side to it. Do I want things to be very protective, or do I want to protect my banks? Do I want to, so sometimes they're great, sometimes they're not great. This one is okay. It does update some ambiguities, which is good too. And like, for instance, in this insolvency determination, it says debts subject to bona fide dispute are not considered. So if someone's trying to create a constructive fraudulent transfer case against a defendant, and they're trying to prove that the defendant went insolvent, well, the debts that are at issue, they can't add those debts to the mixture when they try to prove insolvency. That's very debtor friendly. Partnership assets. It used to be where no consideration is given to partnership, the actual partner's assets, right? That's creditor friendly. You can't include those assets when you make your insolvency determination. It's got a very nice choice of law. We'll get more into choice of law and how that works section, the new act. Basically, it was a mishmash of how, let's say you had litigants in 4 states and debtors in 2 other states, and everyone's suing everyone. What fraudulent transfer law applies? Which collection law applies? And basically, you ended up with a race to a court. The first one to get there was trying to register the judgment. And then that judge, if you go to Delaware, a lot of times, the Delaware law is going to be familiar to the judge. They're going to use Delaware law. Go to California, they're going to want California law. But it might not have anything to do with the case. So they made a very nice change in the new act with respect to the choice of law, and it's the principal place of business of the debtor, if it's a business. And if there are many places of business, a chief executive office, if you have to find one of many. And if it's an individual, it's their residence. So I like that. That created a lot of clarity to the choice of law issue. The burden of proof, it's preponderance of evidence. It mentions series entities. Series entities we thought were going to become very popular, but very few states really like these series entities. That's a means of breaking up, for instance, an LLC into a number of series and dropping different assets into the different series. If someone sues one series, they can't get to the asset to the other series. It's become kind of seriously flawed, but it's an interesting idea. It didn't really take off that to a huge extent. And again, we get into is fraudulent transfer fraud. and it kind of the new act avoids the fraud word a lot, which is good, but it also goes into the comments that, here's the comment suggests proving a debtor's intent to hinder, delay, or defraud. But it's not fraud. It's you're moving an assets away. You're not misleading someone to take financial gain. So it didn't completely solve that. We think it probably should have. Future creditors, it really provided no major clarification, which is creditor friendly. In other words, you don't have the Shackleton ruling where, if this person really wasn't contemplated when I made my transfers, when I became protected, they really don't have a case. It doesn't say that. If they became a future creditor and you became insolvent, they probably have a case. And then, you have this, is fraudulent transfer fraud. I know I'm kind of harping on this, but it's a major issue. Somewhat unnoticed, this case went to the Supreme Court. It's a bankruptcy case, which is a little bit different. And this Husky versus Ritz moved assets around a number of entities. It went to the U.S. Supreme Court, and they pretty much ruled that fraudulent transfer is fraud. It's bankruptcy, so it's a little bit different. What happens in bankruptcy, if you can prove fraud, which really I'm not sure was contemplated as fraudulent transfer, then you can prohibit the discharge of indebtedness. So if you're a creditor, you don't get discharged out if there was fraud associated with the bankruptcy filing. So they really want to prove fraud if you're a creditor. Other aspects involved was, a lot of times what we do when we do asset protection plans is we have another purpose. Because one of the principal means of breaching these plans is someone saying you intended to avoid me, and it's not a bad idea to say, well, no, I had a number of purposes. One was estate planning, one was I wanted to take care of my kids, etc. It neutralizes the idea that you were trying to avoid a creditor. Again, we really only do planning with respect to people who basically have nothing going on. If you have something going on, you just have to know that there's a chance that your plan's going to get unwound if this individual has a significant claim against you. And if you go ahead with planning, you may want to have another reason beyond avoiding this individual, and you may want to leave assets in there inside your own name just to not be subject to the insolvency claim. These are two cases in Stewart and the BB&T. They're kind of interesting.
Gary, before you get into those cases, I'd like to ask another question here from one of our viewers here. So in Florida, if you have a judgment against you and you own a home in your name that is homestead protected, if you sell that home and make a profit, will that profit be accessible to the creditor? So in Florida, homestead protected home, you sell the home, will the profit be accessible to a creditor?
That's a great question. The way it works, there's a case on it actually. So we've got a lot of people from New York that joined us. So the idea in Florida is it's an exception to the fraudulent transfer rules. you can actually, I know it sounds crazy, you can actually be collected against, subject to a huge judgment. They're coming after you, and you can take exposed cash and buy a Florida homestead from anywhere on earth, established, as long as you establish residence here, and no one can take the house. There's some exceptions to that in bankruptcy, but it's absolutely ironclad in the Constitution. I know it sounds odd. So the question is, if I have a home and I'm subject to litigation or I'm subject to judgments, and I sell the home, my principal residence, what do I do with the cash? Is it exposed? Are the profits exposed? And the answer is not if you segregate them. So you close with the title company keeps the proceeds, or you have a special account that has nothing else in it. Proceeds go into that account, and within a reasonable amount of time, you buy another Florida homestead. So if you segregate the funds, and within a reasonable amount of time, you buy another Florida homestead, they're protected. We'll get into a case here. It's a sideline of the case, but someone didn't do that, and they lost out on that. But if you don't segregate, and if you use the money for something else, anything else, you can't buy an insurance policy. A lot of people, they say, oh, I bought an annuity. No, it's not protected because you've got a creditor, and you'll be shown to avoid the creditor. It's generally protected, but it's subject to fraudulent transfer law. You have to buy another house that's protected. So
as long as you buy another place within a reasonable amount of time.
Right. And you segregated the funds. You can't intermingle the funds.
Continue.
Okay. So BB&T v. Hamilton Greens. This is a fraudulent transfer case, a very large fraudulent transfer case, very complicated case. I'm pushing the buttons here, and one thing's coming up, I love it. So the background on this is you had a real estate developer who amalgamated several $1 million and made an investment in a large property and guaranteed the debt. Loan, got the loan, bought the property, the investors put their money in. But interestingly now, so you had a number of wealthy investors, several of them guaranteed the debt. And the property was very valuable when they started the transaction. So as will happen in a number of these cases we'll get into, they happen during the real estate downturn where everyone was absolutely crazy to get as much money lent to them as possible, paying as much as they possibly can for all the real estate, and then you had the complete collapse of the market. They defaulted, and they wanted their money from the founder, the one who put together the deal. Well, 6 months into litigation, the founder, it seems like a fraudulent transfer, basically funded an offshore trust with 1.7 million, which was all the money he had. You're in fraudulent transfer. I think you're knee deep in fraudulent transfer territory there. And the bank won the judgment and sought to collect. A lot of times what happens with these individuals who aren't properly guided is they create a foreign trust and they leave all the assets, in Florida or wherever they live. So what he argued, the defendant, was that the property, when he made the transfer, was still worth much more than the loan, right? He also argued that why would I be concerned and why would I have the intent to transfer away from the creditor if we've got 5 other investors on the personal guarantee and they're absolutely loaded. He also, there was a plea in a lot of these cases, you'll find there's a plea to their personal situation. There was illness in his family, and I think he suffered from something as well, and he made that plea as well. But it was a pretty good defense based upon what seems to be a totally obvious fraudulent transfer. And intent became the factor. Let me see if, so that's the next case. So intent became the factor. And what got missed, in my opinion, was where's the constructive fraudulent transfer claim? In the BB&T case, he moved the assets. He did not get back reasonable consideration that was exposed, right? And he became insolvent for asset protection purposes. I don't know how he could win. He won. It just goes to show you that if you have a kind of a consideration with respect to the finances and some sympathy plea, sometimes you can win. The other case is Stewart, which had some similarity to it. The moral of the Stewart case is, this is a bankruptcy case, unlike the BB&T case, is make friends with the trustee. A lot of times, if the trustee is asking for a particular asset, or sometimes the trustee just wants to get paid. I know that sounds terrible, but that's my experience. If there's any trustees out there, I'm sorry, but sometimes it's kind of, they want to settle. They want to settle the claim out. Especially when this was going on. There were so many bankruptcy cases. They just kind of want to move through the dockets of these things. And so, in this case, it was another bank guarantee. It was a commercial loan. And into the bankruptcy, Stewart transferred $19 million into trust for their kids. Didn't get back reasonable consideration. I don't know if they went insolvent and didn't get into that. But they left some assets, and they were very wealthy, and they negotiated a settlement with the trustee. So some creditors saw what was going on. This is pretty common. I'm not a bankruptcy lawyer, but I've seen this several times. And said, well, hold on. These assets were fraudulently transferred out to these trusts. We want access to the $19 million in assets. And apparently the relationship between the stewards and the trustee weren't bad. Wasn't really, they had kind of established a pretty good settlement. And the court was probably totally overwhelmed. So the court said that the settlement is at the trustee's discretion. And this is the standard because it doesn't fall below the lowest point in the range of reasonableness. So the idea is figure out what the trustee needs if you are in a fraudulent transfer situation or conveyance situation, depending on your state, and get it done. Because once you settle with the trustee, it's very difficult for the other creditors to kind of break that settlement open to reach assets that have been transferred. It's kind of enlightening. I got some stuff on what's the reason for your planning. And then we get into, so beyond the substance of fraudulent transfers, you have the statute of limitations. And the statute of limitations is basically a humongous factor in a lot of these deals. Because remember, someone gets into trouble. The surgeon leaves the scissors inside. He thinks, oh, wow, I've got a problem. Starts moving everything out. The litigation can take years. Can take absolutely years. And once the actual statute runs, you can't make a fraudulent transfer claim. So all the assets that went out are not reachable. It's missed by a lot of practitioners. You got to realize most litigation people are very good at winning a negligence case, winning contract cases, winning, whatever, transportation litigation, medical litigation, but they're not very good at collecting. They don't know the rules. They don't understand fraudulent transfer. And a lot of times these statute of limitations lapse. In most states, you have a 4-year rule and then 1 year from discovery, which means that 4 years, after 4 years after the transfer, you can't make a claim unless you didn't know. You can claim, look, I didn't know about this transfer, so I have a year. I have a year to make a fraudulent transfer claim. In bankruptcy, it's different. Nevada has a shorter statute. It's 2 months, 2 years and 6 months. Bankruptcy, if you do any asset protection work, they can look back 10 years. Basically, if you do any asset protection work, you're not going to go bankrupt. This is the Trusco case. Pretty interesting case, involved Florida and Delaware. It was a construction claim. And, again, you have these litigation people that are making mistakes on the asset protection side. In this case, there were fraudulent transfers made, and the case was won. The creditor won the case, but filed in Delaware to collect. Well, if you go to Delaware, it's very likely that the court in Delaware is going to apply Delaware law. The LLC was a Delaware LLC. Well, if you want to try to breach the Delaware protections, you have to stay out of Delaware. You wanted to, in this case, sue in Florida, hoping and making the argument that Florida law applied and that protections don't apply because we're in Florida. They went to Delaware. The Delaware court didn't even address the substance of the fraudulent transfer claim. They just said, look, it's been 4 years, you're out. The gavel comes down. That's the end of the whole case. They might have won the case, but they can't get any of the assets. The Bel Rio is kind of what can happen when we try to when other law gets pled in. So in Florida, you have what's called proceeding supplemental, and that's my impression of it is that it has a number of ambiguities to it. So beyond the fraudulent transfer claim, which is a 4-year to make the claim 1 year after you discover it, you have the ability to bring proceeding supplemental, which is to collect. It's basically your ability to collect on the judgment during the term of the judgment, which is 20 years in Florida. So we have the Schultz, who had this Barefoot Cottages company. They guaranteed a commercial loan, and during the litigation, they transferred millions of dollars into an irrevocable trust. It was kind of sloppy. The wives were the trustees. It was an obvious fraudulent transfer. But they lost at the trial level because 4 years had passed. It was onerous, though, so the court allowed this claim for proceeding supplemental and said, we're going to allow a claim similar to fraudulent transfer for proceeding supplemental and say that the action is not time barred. We're going to allow you to make that claim. We don't know. We don't know with this case how much weight it's going to have, but it seems to open up the statute of limitations on fraudulent transfer in Florida, which is not good for Florida debtors, to be honest with you. Schmidt is a similar where the court kind of went out a little bit, I thought, in Hawaii. Basically, you have this 1 year that stays open until the creditor knows about the transfer. And in Schmidt, it's not just know about the transfer. They have to know about the fraudulent nature of the transfer, that it was intended to avoid a creditor, which is a pretty high standard. So what does this all mean? What it means is when you have a client that does asset protection and has a structure in place, go ahead and send a letter to the bank, to the creditors that says, we've engaged in estate planning or whatever you're doing, and we've done some asset protection planning, and these are the assets that we've put into the structure. Who you have to send that to, we don't know. I mean, if you send it to the loan rep, it's going to be either thrown in the trash or it's going to be put in a file. So I've never met one that had any idea of how any of this stuff works. But I think technically you've given notice. So that open 1 year period closes. They know now, and they've got 4 years to sue for the asset in case there's a breach. There's these different theories. There's academic theories, as nest egg. If you're saving money every month, well, if you're moving that money into a protected vehicle and you keep doing it, well, your intent is to just keep doing it. You're not avoiding a particular creditor. And we had touched on these valuation issues, which comes down to this insolvency. You have to prove insolvency on constructive fraudulent transfer. Contingent claims, well, those are worth less. That's less of a debt. Disputed claims, it's not the whole claim. It's the percent of the claim that's likely to occur. And they have to do with the equivalent value. And like this BB&T claim where he claimed, look, when I made the transfers, the property was worth more than the loan. So you didn't have insolvency. You kind of have indirect insolvency because he was a guarantor, but his intent was not to avoid the creditor. There's some exceptions to a lot of the asset protection stuff. In Florida, we have a tremendous amount of assets that are exempt, including what I mentioned, the homestead, where you can literally be stuffing your homestead or pay off your mortgage, running away from a creditor, and that has some exemptions. I mentioned it, we have a lot of New York people on the line, but there's a lot of New York people moving here, and that it's an interesting concept if someone is highly encumbered in debt. Not looking for OJ, but it's good to keep that in the back of your mind. This is more on the homestead. I don't want to spend too much time on this. We've got until 10:40, so we have another half hour, which is good, but I've got a lot to cover. In Florida, the homestead, that's this protected, wildly protected. If you live on the property, the courts have said that it's your farm next to your house. It's a mobile home park. It's the duplex. It's the whole thing. They have limited it. I mean, they had a guy with a nightclub. They didn't include that, but it's pretty broad. There's some interesting stuff happening. I actually wrote part of a statute in Nevis, West Indies. It's a very protective LLC statute that's in this offshore jurisdiction. We oftentimes put it under a foreign trust. For instance, if you want to divide up properties or you want to divide up accounts, you can use an LLC. It's just owned by the trust. These are very flexible, very protective entities. Part of that is limiting this debacle of fraudulent transfer. So it's not, it's the statute doesn't stay open for a year. We don't know when it closes. We don't have to give notice to close up that 1 year period. It's just a year. Basically, it's not going to happen. So what I mean by that is if you're in litigation in the States and you fund a Nevis LLC and the Nevis fraudulent transfer law applies, it'll be a year of litigation before anyone even talks about Nevis or thinks about that transfer. So we kind of, you have to prove it beyond a reasonable doubt. You have to post bond in Nevis. It's very burdensome. It's a very protective statute. We're going to talk about a case where they abuse the statute, which is not a good idea, which doesn't work, but it's a very protective if you want to do some regular planning. We're going to get back to this avoid bankruptcy. This is a pretty good topic. I've got to have some detail for it on you. Bankruptcy, you know, if you're encumbered with debt and your assets are limited, bankruptcy works great. You can discharge the debt. You have to give up your assets, and you know you may be able to keep quite a bit if you have limited assets. Your assets. But you have entered the dragon. I mean, the rules, the discretion of the judge completely changes. They kind of make their own laws sometimes because they're allowed to based on public policy. It's not where you want to be if you have significant assets. You want to be asset protected, and if something goes wrong, you want to have that nest egg locked up. You don't want to have to file and enter a bankruptcy order where a judge is, you know, a lot of times going to really try to protect the creditors. In the 80s, a line of cases started to undermine those who had engaged in asset protection. Basically, what happens is an individual, before they knew how bad the bankruptcy court was going to react to asset protection, got involved with a foreign trust, did the foreign trust planning. Sometimes it involved a fraudulent transfer. Sometimes it was just planning. And then had a debt, or, you know, some of these are just like a divorce or a business debt, and made the mistake of filing bankruptcy thinking, you know what, I'm going to keep my trust and I'm going to discharge my debt and I'm going to live off the trust. Beyond that, a lot of these individuals kept assets in the States, because the general rule when you form a trust, no matter where you form it really, is that you pick that jurisdiction, you pick the law of that jurisdiction, and that's what applies because that's what worked for so many years. But what's happened is, and this is this Portnoy case, which was in the middle of this line of cases in bankruptcy, is that the courts say, no, we're in bankruptcy and we can apply public policy. And we think it's against public policy. Public policy used to be like you couldn't kill yourself to get an insurance policy claim. You know, I mean, it was like wild criminal actions. But the bankruptcy kind of lowered the bar a little to, you know what, Larry Portnoy, you're in Connecticut. Your assets are in Connecticut. Your wife's in Connecticut. The creditor's in Connecticut. I'm in Connecticut. We're going to apply Connecticut law. It's not a Jersey, I think it was Jersey Channel Islands trust. It's a Connecticut trust, and Connecticut doesn't protect trusts that you form for your own protection. So all those assets are exposed. If they're here in the States, I'm taking them and I'm giving them to your creditor. And that's kind of how it goes now. A number of cases affirm that, and basically you can't use the asset protection in bankruptcy if you're kind of a bad actor or you're getting a divorce or whatever. It doesn't really work like that. You want to stay away from bankruptcy. There's a couple more modern cases I think we included. This was a similar case around the same time as, I think just after Porter, 91, was Lawrence. And you have to be careful in bankruptcy. Lawrence had a bad attitude and was disrespectful to the court, which is always not a great idea. He had gotten into a massive debt to Bear Stearns on a stock trading account. And he made a fraudulent transfer out to a trust, and then he changed jurisdictions. I think he was in the Channel Islands and changed to Mauritius or something like that, which was a popular jurisdiction at the time. And he filed bankruptcy. So the same thing now, instead of, you know, having years of litigation, trying to figure out what he did, where he did it, you know, and coming to some kind of settlement, which is probably what he would have gotten. I'm not sure he would have deserved it. He files bankruptcy to discharge the Bear Stearns debt instead of working it out. And the bankruptcy court says, no. You can't just move stuff. You can't fraudulently transfer stuff into a trust. And he says, well, I don't control the trust. I mean, it's a trustee controls the trust. Go after the trustee. They said, we're not going after the trustee. we're going to put you in jail until you cause that trustee to disgorge the assets. You know what? He never disgorged the assets. He stayed in jail for 7 years. I think it was 6.5 years. And he got out and he kept the assets. But you have to be careful, because if they think you're doing a fraudulent transfer and you don't do what the court says, they can put you in jail for civil contempt. Now we have later cases where they could consider that potentially a criminal act, and they could put you in jail for even longer. You got to be careful with the bankruptcy court.
Gary, we have another question.
Sure.
Can an LLC protect assets in bankruptcy?
Yeah, an LLC can protect assets in bankruptcy. You just want to avoid fraudulent transfer. So generally speaking, bankruptcy, you've got different states. Some states are what are called opt-out states, some are opt-in states. It's basically what's going to happen is the protective law of your state will still govern. So if the law of your state allows tenancy by the entireties or LLCs, and it protects you, those assets will be protected. Those assets will not be available in bankruptcy unless you did a fraudulent transfer, and they can try to unwind the transfer because you did it to avoid a creditor. If you didn't do it to avoid a creditor, that was just planning. We've had a number of clients later go bankrupt and all the assets were protected. So LLCs will still retain whatever their state law protection is. You've got to pick the right one. We're going to talk about choice of jurisdiction in a minute. But if you do it and you're not in a litigation at the time, it will generally be protected. Yes.
Okay, great. I do notice that we have some hands up. So once we're done here, we'll open this up so anyone with a hand up can ask their own question. But for now, let's continue, Gary.
Okay, you let me know, Tony. In re Huber is very similar to Portnoy. In re Huber is a case that involved a contractor who got encumbered with debt. Some of the transfers were not. I don't know if some of the transfers were fraudulent transfers. Some of it, I think, was legitimate planning. Created an Alaska trust, an asset protection trust, where you fund the trust for yourself, and made the mistake of going bankrupt. So they went through the Portnoy, basically, analysis, and they said, you know what, Hubert, you're in Washington State. The assets are in Washington State. The trustee's in Alaska, but your co-trustee and protector are in Washington State. We're going to apply Washington State law, which does not allow you to create a trust for yourself, and they took all the assets. It's really dangerous when you get into this bankruptcy when someone can say, well, as a matter of public policy, we're just going to go ahead and apply whatever law we want. And that's what happened. The funniest, I don't know, funny for us, not funny for Morton. I don't know, did we hit Mortensen? Oh yeah, and 2 slides later we hit Mortensen. This is just a slide that talks about how, if you have clients that are moving to or resident of Florida, how the bankruptcy rules with respect to the homestead change. You can't just move to Florida anymore and go bankrupt and keep your house. You've got to be here 1,215 days. You've got to be in that house for 1,215 days. Otherwise, you only get the 160,000. It's gotten bigger over the years. It's like 170,000 now of exemption. Got to be very careful with that. And also on fraudulent transfer, you have this 10-year look back. So the statute does not run after 4 years. If you were avoiding a creditor, they will pull it even out of your homestead, which you can't do out of bankruptcy. Actually, you can do an OJ, and if you don't go bankrupt, you're fine. This is the Mortensen case. So the Mortensen case is kind of a wild case. It's a mountain man in Alaska, and what he decided to do is he made his own self-settled trust. It was sloppy, but I think it satisfied the general requirements of doing a self-settled trust. He was in Alaska. He had an Alaska trustee. He funded the trust, and several years passed. The statute ran, 4-year statute ran on fraudulent transfers. He goes into divorce. And then his wife says, you know what, he had all these assets. He funded this trust to avoid me. I know I'm late, but I'm suing him. I'm suing him for divorce, and I want all those assets. And so he goes bankrupt. And when he filed bankruptcy, he extended the statute of limitations period from 4 to 10 years. And she got all the assets. It's absolutely, you gotta be careful with this bankruptcy. You also have to have competent counsel. So, I mean, that's absolutely amazing that someone let him do that. That's Mortensen. The bankruptcy, you have to be careful, because a lot of what early in the seminar I had mentioned that it's not a crime to do the fraudulent transfers. It just allows the creditor to go get the asset. Well, sometimes in bankruptcy it could be a crime, and if it's fraud, we discussed, you can lose your attorney-client privilege. You can go to jail. Avoid bankruptcy. This will slide us into the LLCs, which we're going to hit for a few minutes next. It was in bankruptcy that the single member LLC got exposed. The movie star Ashley Albright went bankrupt. She had several single member LLCs, and the statute in these jurisdictions, I think it was Colorado, the statute in these jurisdictions does not distinguish the protections between single and multi-member LLCs. It just says they're protected. They're just subject to what's called the charging lien. But the bankruptcy court went through a whole analysis unrelated to the statute to reach her single member LLCs. Basically what happened, I think it's on the next slide, is, oh no, it's not, it's on a later slide. So what happened basically is that you had corporations over 100 years, and you had partnerships. We no longer really should have partnerships. That's the handshake. But in partnerships, you're liable for the operations of the partnership. But the flip side of being liable for whatever happens in the partnership as a partner is, if someone sues a partner, all they can get is a lien on the partnership interest. They can't take the partnership interest. And that was kind of adopted into the LLC statute. So you can't take the interest. But in partnership law, you have to have two partners to make a partnership. So the bankruptcy court said, no, this is from partnership law. So you have to have two partners, or else you don't get the protection. It doesn't say that in the LLC statute. It doesn't say anything like that. But that's how they got to Ashley Albright's single member LLCs, and it was downhill from there. I had mentioned in the Catulli case, if you do crimes, if you do fraudulent transfer, it can be viewed as fraud, and you can lose your attorney-client privilege. These were the facts. I'd gone through some of the facts of the Catulli case. They were basically criminals that moved assets. There was a third party that hired the same lawyer, and the court really focused on the fraudulent transfer being fraud, took the assets, didn't allow the discharge of indebtedness, and also removed the attorney-client privilege from them and the other party that used the same lawyer. I'm running through it because we hit those facts already. And here are your takeaways. Here we can of course get you a copy of the seminar. I just want to make sure we hit all the slides. We hit Husky for a minute. In the Husky case, we had an individual move assets around. The Supreme Court, all 8 judges of the Supreme Court said fraudulent transfer is fraud, and that amounted to, well, you can't discharge your indebtedness. You can't file bankruptcy for fraudulent purposes. And fraudulent transfer is fraud. It's not. It's a totally different claim. But in bankruptcy, the Supreme Court said it, so it's true. Fraudulent transfer is fraud. It's affected several jurisdictions. I had mentioned that if you do fraudulent transfer, you will entwine the transferee. They will be sued to get those assets. And in bankruptcy, you're looking at punitive damages, very uncommon in civil court. These are some of the general ideas to avoid bankruptcy as we go into the last 10 minutes or so. you completely expose your structure. You're subject to other remedies as well. It's just not a very good idea. So we had mentioned Albright. This is, now we're on a new topic, single member LLCs, and that the charging order, which is the remedy against a defendant, a debtor who has an LLC. So if someone has an LLC, it's not like corporate stock. Corporate, you can just take their stock. In an LLC, you can create a lien on their LLC interest, and any distributions that come out, you get as a creditor. Do they have to make distributions? Are you controlling decisions? No. So what happens is you want to be in the LLC, not the corporation, because even if someone gets a charging lien on it, on the equity of an owner, of a member, it becomes a settlement. Most of the time, the creditor is advised that there will be no distributions. And so the creditor says, well, what can we do here? And you settle for a fraction of the money loan. So it is very powerful, the LLC. It's not as powerful as a trust, but it's more flexible and much less expensive in general too.
I have a question.
Sure.
What's the difference between a charging order of an LLC interest and the foreclosure of an LLC interest? So difference between a charging order for LLC interest and a foreclosure of an LLC interest.
Yeah, so the original idea with LLCs is that they're a protective entity, and the protections come from the fact that if someone sues an owner, they cannot take the equity. All they can do is lien the equity. So if money comes out, they can get the money if it ever comes out. That's the general way that LLCs are protective. Foreclosure, if you sue a shareholder for corporate stock, you can take the stock. You can foreclose the stock out in civil litigation. What's happened to the single member LLC, it's very relevant, the question is very relevant to the topic we're on here, is that some jurisdictions now, and the bankruptcy court now, allows for foreclosure. So you can sue and you can lien and you can foreclose the lien and take the equity of a single member LLC. And there's some argument in a few weak jurisdictions that because of the way the LLC statute's written, that someone could foreclose the charging order in those jurisdictions. You want to stay away from those jurisdictions. I can get a list of those to whoever wants if you just send me an email. They could foreclose. So foreclosure means you just own it. You get everything, you vote, you get all the value, and you get all the distributions. It's different from a lien, which means you just get the distributions if they're made. That's the difference. With respect to single members, we went through Olmstead. We talk about some of the solo member states, Delaware, Nevada. They say in the statute, no, everyone, it's subject to charging lien and only a charging lien, and including a single member. And that language in those statutes comes from that Olmstead case. Please don't overinterpret what we're doing here. It's protected, even if it's a single member. And then you get into choice of jurisdiction, which is what we'll hit, I think, is our last topic. So we have the Curci case, and the Curci case is a fascinating case where someone who had $200 million didn't even get basic legal advice. So Curci puts $200 million into a family conglomerate, really what amounted to a conglomerate, very wealthy person, and puts his wife on for 1%. It's a Delaware entity. Arguably, you can take Delaware. Delaware allows for entirety. He could put his wife on as entireties, or they could do a trust to own the Delaware entity, which is much more protected. Instead, he's on for 99. His wife's on for 1%. And the question is 1% enough? Is 1% a multi-member LLC where we can avoid this this debacle where they're foreclosing single member LLCs. And so Curci creates this massive structure, takes a debt out for $5 million, which was like nothing for this guy. And apparently there was some kind of personal dispute, doesn't pay the debt. The creditor, I'm sorry, Curci was a creditor, Baldwin was a debtor. It doesn't really matter. So Curci, the creditor, gets the charging lien on the LLC and says, I got to get into this LLC. This is totally unfair. This guy's got $200 million and he's flaunting it at me. I can't get in. And he made $178 million in distributions. And now he says he's not going to make any distributions. I'm not going to get anything. And the law in California said you can't get in. But the law was based on you taking corporate stock. It said you can't, veil piercing doesn't apply to corporate stock. But the reason really was because corporate stock's totally exposed. There's no veil piercing necessary. You just take the stock. So the appellate court said, no. We're going to allow veil piercing in this situation. It didn't really get into because he owns 99%. This was flagrant. It didn't really get into that, but they allowed it to go back to the trial court and potentially pierce through to get Baldwin's equity. So we never do this, but you never want to do 99-1. At least for instance, if it's like a third marriage and it's a prenup situation and they don't want to go owning it together, add trust for the kids for 4 or 5%. Create a multi-member situation where there's truly a limitation on the lien, where it really looks real. And that's Curci, and I think it's pretty telling. You really have to set up a nice structure. We mentioned here, why was there no discussion of Delaware law? Because it was a Delaware entity. It wasn't even discussed. It wasn't even, can you imagine that the attorney didn't even raise the issue because Delaware would have protected it. And then we get into choosing a jurisdiction. They're all different. You have to choose the right jurisdiction. Whether or not a court is going to uphold that is going to a lot of times depend on the facts. We mentioned the internal affairs doctrine. That means we look to the internal affairs of the statute that was used to form the entity. Sometimes that's respected, sometimes it's not. We use a Delaware entity because it's very protective. If we're in Florida, we would hope that the court say, hey, we're going to respect the internal affairs of Delaware. It's in our Florida statutes. I believe New York's the same. They should respect Delaware. Which fraudulent transfer law applies? Well, sometimes we're going to race to the state that has the strongest if we're the creditor or the weakest if we're the debtor.
Gary, I have a couple of questions.
Okay, I think we got 5 minutes.
Yeah, no, we have time here. So the first one here is how do LLC laws differ?
Okay, well, LLC's laws differ in a lot of ways. We had this Ashley Albright case and a number of the single member LLC cases, and we got into a situation where if you form a single member LLC, for instance, if the court goes under Albright or the new Florida case called Olmstead, it's not protective. They can just foreclose out your single member LLC interest. A lot of states have not corrected that. Florida went in and they corrected it for multi-members because the case actually exposed multi-member LLCs. It was so onerous, the actual Florida Supreme Court case. But Florida really didn't correct it, and for instance, New York didn't correct it. Delaware says we're going to correct it. Nevada, Alaska, we're going to correct it. You cannot distinguish between a single member and a multi-member. You are never subject to more than a charging order. You cannot foreclose these entities. It is the exclusive remedy. They write into the statute it's exclusive. That's really a significant difference in terms of what are the different how do the different LLC statutes work.
Okay, Gary, could you discuss insurance as a tool of asset protection? How much is needed? For example, if a client is worth $10 million, do they need dollar for dollar insurance? For example, a $10 million liability policy? So could you tell us a little bit of
Well, it's a
insurance?
financial, yeah, sure, Tony. It's a financial, thanks for asking that question, who's ever out there. You know, there's maybe 40 really high-end asset protection lawyers in the country, and a few of them will say, you know, just forget about insurance. I don't agree with that. I don't agree with that at all. We don't want to get into this debate. We want to have the safest structure, you know, but some clients will be more safe than others. Some are in high risk professions, etc. You know, most of the time, depending on the situation, the general liability insurance and the umbrella is so inexpensive that we offer it up. We offer it up. Look, you can take the liability coverage. We're going to make sure you get paid. We're going to be on your side so that the insurance company pays you. Or we can spend 2 years litigating this. And here's the way the cases work. You know, typically they have to, the creditor or, you know, the plaintiff has to find an expert to figure out how to breach it. It's wildly expensive to try to breach these asset protection structures. Or we can just go the insurance route. And you know what? Almost every single time they go the insurance route, I would recommend insurance. And until it becomes where, well, that's not efficient, until it becomes inefficient. So that's my advice.
Okay, we have a couple more questions.
Okay.
A married couple with a Florida LLC where each owns 50% and they share the management duties equally. Is this considered a multi-member LLC or a single-member LLC?
Well, that's the Curchi question. First of all, you could have a nice tragedy there by having 50-50 ownership. We see it all the time. So here's the tragedy. You know, mom's a doctor, dad's a contractor. Mom gets sued on a malpract case, and they own the LLC 50-50, right? She loses. They place a charging order on her 50%. What can she do? Absolutely nothing. Absolutely nothing. The idea with this structuring is you have to approach it academically and practically. So 50-50 doesn't utilize the protections available in Florida. If they own it together by the entireties and she's sued on the medical malpractice claim, they can't even get a charging order. They're out on the LLC. So they have the wrong structure. Same with dad. If dad gets sued on a construction loan and it's a tenancy by the entire, cannot get to the LLC. The question then becomes, is this a single member LLC? We don't know. Curchi suggests that maybe it is. If it's husband and wife, maybe it's a single. You know that issue is going to come up. We know it's going to come up. So what we do is we add trusts for the kids. If they've got 3 kids, we do 3 trusts. And you know, if they're of a certain age, sometimes you know they're 20 years or 30 or whatever, we don't use a trust because the parents don't really care. But if we add the 3 trusts for 4 or 5% each, and that's their savings mechanism for their kids, they've got. I mean, I think it would be hard to argue against the fact that they had a multi-member LLC at that point. So the structure is husband and wife tenancy by the entireties, adding the kids. They've got their multi-member, and any claim against either husband and wife. Not if their claim is against both, they get the lien. But if it's only against one, they're out. There's no claim. That's generally not available in New York, though. So you can go with the 50-50. From my understanding, you can go with the 50-50 in New York. You're not in most assets. The tenancy by the entirety is not available. What we do for New Yorkers, we can't practice New York law, but if we have a New Yorker in Florida or coming to visit us, is husband and wife based on the fact that Delaware allows tenancy by the entireties. I know it's a little long-winded, but I wanted to make sure you understood the whole structure. That's the answer to that question.
Okay, let's continue.
Okay, so let's wrap up. When you pick your law, it's very important. You can't be like this Sabrina Barber who got sued by Wells Fargo in a $65 million real estate loan. She gets sued and she starts moving stuff all over the place. She had money in a homestead. She moved it out and lost the homestead. She would have been able to keep the homestead. She moved money into a Nevis LLC, as a fraudulent transfer. The judge had left the assets in a Florida brokerage house. The judge says, you know what? It's not a Nevis LLC. You're here. The money's here. We're going to call it a Florida LLC and take the money. I don't think it's a good ruling, but you knew they were going to do that. She's basically trying to steal the money from Wells Fargo. What they probably should have done was that was a fraudulent transfer. It's subject to Florida fraudulent transfer law. We can take it. I think that would have been the appropriate ruling. The JP Morgan case is similar, but what the JP Morgan case is, because we're wrapping up now, is it's a claim that occurred in Arizona, but they sued in Colorado, and it was a Colorado LLC. The Colorado court said, hey, we're applying Colorado law. It's protective. When you sue in the state where the entity is, you're probably going to be subject to their protections. Arroyos went completely debtor friendly and said, look, I know you've got a main judgment you want to collect here in Alabama, but it's against a Delaware LLC. If you're not confused yet, the court says, you know what? We don't really understand Delaware LLCs. I know this sounds crazy, but they actually did this. You got to go to Delaware. Go to Delaware. We don't understand this. We're not going to rule on a Delaware LLC. It actually happened. And then you have a situation here with Sargent we want to mention because it became law a couple years ago. If you certificate an LLC and you move the certificates to a different jurisdiction, in Florida, the appellate law says you've got to go to that jurisdiction to collect. You can't get the asset unless you go to that jurisdiction. It's very powerful. So you might want to move the asset off, the certificate offshore to your foreign trust or whatever you're doing. And we kind of worked through, we talked about Uber where they applied Washington law. We talked about Wells Fargo where they applied Florida law to a Nevis LLC. All these things had to do with fraudulent transfer. Let's avoid fraudulent transfer. Let's integrate your asset protection plan with estate planning. You might want to leave some assets in your estate. You want to make sure they have value. Sometimes we do appraisals. We talk about just like sometimes we confirm up front. This has nothing to do with the fraudulent transfer. And that's it. My contact information is at the bottom. If you want a copy of the presentation or you would like one of my books, we'd be happy to send that to you.
Gary, I'd like to open it up for questions. We have some people with some hands up. So
great.
Folks, if you'd like as Gary said, if you'd like a copy of the presentation or the outline or Gary's bio, you'll see that they're in the handout section there. So feel free to take a look there. Let me go to the folks that have their hands up. So first, Matt Gallagher, I'm going to open your line up. Let me see here if I can do that. Okay, Matt, can you hear us?
Yeah, I'm unmuted. Does you hear me?
Yeah, yes, go ahead. First, thanks so much for hosting this for us. We greatly appreciate it.
I just wanted to thank you and thank Gary again for coming to present. I wish we could have seen you in person, but with all that's going on in the world right now, we know that wasn't possible this year. But let's hope we could have you back in New York, maybe this summer if things get better, but sometime in the future. This has been a great presentation, as the other two have, to our chapter, and we really appreciate you doing it for us.
Yeah, thanks so much for attending.